Keep Law, Unit 2, Law of Tort. The topic today is trespass to person. So trespass to the person involves the wrongful invasion of a person's right to freedom from interference with his body or with his right to personal liberty. There is no tort of trespass to person. However, there are 4 torts, which are assault, battery, false imprisonment, and malicious prosecution. So these torts are actionable per se. That is, they're actionable without any proof of any actual harm or damage. So in the Commonwealth Caribbean, actions for assault and battery are generally rare, but they do exist, and litigants prefer to seek a redress in the criminal courts rather than the civil courts. So we're starting with assault. So assault is a direct threat of violence which is calculated to, or the effect of which is to put another person in reasonable fear of an imminent physical contact with his person or with his body. So to approach him menacingly with a clenched fist, this has been held to be an assault. So in the case of Stevens and Myers, at a parish council meeting, an altercation took place between the plaintiff and the defendant. The defendant approached the plaintiff menacingly with a clenched fist, but his blow was intercepted by a third party, so someone caught his hand. But it was held that he was still liable for an assault. In Holland Ellis, the defendant accosted the plaintiff as he was riding his donkey along a public road. She held a revolver in her hand and she asked him where he got the piece of wood he was carrying. And so the court held that the defendant was liable for assault, as the carrying of the gun together with the words spoken would put any reasonable person in fear that they were about to be shot. So it has long been doubted whether words alone could amount to an assault, and the old view was that no words or singing could ever amount to an assault. It is believed today that words alone would be an assault if the words are sufficient to put the claimant or the plaintiff in a reasonable apprehension of a battery. So for example, where the words are uttered in darkness and the claimant cannot see the aggressor, this would be held to be an assault. Now we're going on to battery. Battery has been defined as a direct act of the defendant which has the effect of causing contact with the claimant's body without the latter's consent. Battery is the intentional application of force to another person. A battery cannot be committed negligently. It requires intention. To slap the claimant in his face is a battery. To throw an object at him is an assault, but if the object strikes him, then it is a battery. Very often the threat of violence will be immediately followed by an actual application of violence to the claimant's person. So then, in a case like that, there is an assault and battery. In loose language, this is frequently shortened to assault, but for the purposes of legal definition, it is an assault and battery. It is not necessary that there should be any bodily contact between the defendant and the claimant. It is sufficient that if the defendant brings some material object into contact with the claimant's person, that'll count as battery. So for example, throwing a stone, spitting in his face, knocking over a chair that he's sitting on, setting a dog upon him, all of this would be considered battery. So in the case of Wilson and Pringle, in this case there were two 13-year-olds who were walking down a corridor at school, and the defendant pulled the bag of the claimant in an act of horseplay, so they were wild playing. The claimant fell and hurt his hip. The claimant felt that this amounted to a clear case of battery. The trial judge agreed, but then gave leave for the matter to be appealed to a higher court. And it was held that the test to determine whether there was in fact a battery was whether there was some hostility involved. In the instant case, the court found that there was no hostility, and as such the defendant was not liable. They were saying that everyday contacts are to be expected and cannot amount to battery. So for example, to jostle someone or push someone in a crowded bus or in a sports stadium will not be held to be battery unless the defendant acts in a rude or an inordinate or purposive manner. It is not a battery to touch a person in order to draw their attention to something as well. Right? So now moving on to the defenses to assault and battery. So the first one is self-defense. And an assault and battery is justified if committed in reasonable defense of oneself or another. The act must be genuinely defensive and it must not be excessive. The battery must be committed in actual defense from an attack and not by way of retaliation after an attack. The self-defense must have been reasonably commensurate with the attack. Now, what is reasonable depends on the circumstances. So, if the claimant threatens the defendant or another person with a deadly weapon, for example, the defendant may defend himself or other persons with a deadly weapon. If the claimant punches the defendant with his fists, the defendant will be justified in defending himself with his fists, but not in pulling out a gun and shooting the claimant. Unless, of course, it's a rare circumstance where the claimant is some kind of expert who would still be able to, whose attacks or whose arms and legs, based on his training, could be seen as a deadly weapon. So in Cachay and Nemeth, the plaintiff was trying to kiss the defendant's wife at a private party against her will. The defendant struck the plaintiff with a karate chop across his jaw and broke it, and was held that the defendant was entitled to use force to defend his wife, but he had used excessive force and was liable in battery. So the second defense is parents and teachers' authority. So a parent or guardian has a right at common law to punish a child and will not be liable in trespass to the person in doing so, provided the amount of force used is reasonable in the circumstances. So in the case of Myers and AG, in this case the head teacher of a secondary school in Barbados gave a female student 3 lashes with a leather strap as punishment for rubbing something called cow itch on the teacher's desk. The student suffered minor injuries as a result. She, or I assume her parents, sued for battery and was held that the head teacher had the right to administer corporal punishment both at common law and under the Prevention of Cruelty of Children Act and under the Education Act, and that the head teacher's decision to administer immediate punishment for the breach of discipline was justified in the circumstances. The court held that the head teacher had used no more force than was reasonably necessary in the circumstances, and the minor injuries caused to the girl were accidental and unintended. The head teacher was not liable for assault and battery. So the third defense is consent. A person cannot complain about any interference with his person to which he has consented. Where the claimant consents to whatever would otherwise have been an assault or battery by the defendant will have a complete defense. So a participant in a contact sport such as boxing or wrestling cannot recover damages from his opponent for blows inflicted on him during the fight, for he will be taken to have consented to them. A footballer cannot complain of a tackle or other bodily contact that he encounters during the normal course of a game, However, it will be different with a deliberate foul inflicted with the intention of causing actual bodily injury. So if it was a deliberate jump kick or a punch, if the blow is quite unconnected with the play, the defendant will have no defense. An apparent consent will be inoperative if it is induced by fraud or concealment. There may be an actionable battery where, for example, the claimant permits the defendant to touch him with a piece of metal which, unknown to him but known to the defendant, is charged with electricity. It is a trespass to the person when a doctor deceives a naive girl to submit to indecent contact by deceiving her into believing that his act is a necessary part of the treatment. So now we're moving on to the remedies for assault and battery. And the usual remedy for an assault or battery is damages. The damages are assessed in the same way as in cases of injury caused by negligence. So general damages are compensatory and fall under certain heads. The usual heads of general damages in personal injury cases such as pain and suffering, loss of amenities, loss of expectation of life, loss of earnings, they apply. The claimant may also recover aggravated damages for injuries to his feelings, for example, dignity, disgrace, humiliation, or mental suffering occasioned by the assault. Right, so now we're moving on to the second subtopic, false imprisonment. Or the third, I should say, the thought of false imprisonment. So, the thought of false imprisonment is committed where a person is wrongfully deprived of his liberty. And it often happens where police officers arrest or detain persons without lawful justification. The term false imprisonment is misleading. Here, false means only wrongful or unlawful. Imprisonment here means any physical restraint. So, for example, where a police officer restrains a suspect by taking hold of his arm, or where a whimsical lecturer locks his students in a lecture hall after a lecture without any real justifiable legal reason, the tort of false imprisonment is committed. So, for false imprisonment to be committed, restraint must be total. A partial restraint is not sufficient. So, say for example, if one door of a two-door house is locked and the claimant could have easily escaped through the other door without risking life or limb, there is no false imprisonment. The restriction must also be unlawful. So, a prisoner who is wrongfully confined to his cell by prison authorities in breach of prison rules has a good cause of action in false imprisonment, even though his original imprisonment was lawful. A person may also be falsely imprisoned without being aware of it. A person may be imprisoned while he is asleep, while he is in a state of drunkenness, while he is unconscious, or while he is a lunatic. So, an example of false imprisonment was found in the case of Meering and Grahame-White Aviation Company Limited. And here the plaintiff was taken to the defendant's office for questioning. While he was in the office, and unknown to him, two of the company's security officers stationed themselves outside to prevent him from leaving. It was held that in an action for false imprisonment, such an action would lie in these circumstances. A person may be falsely imprisoned without being aware of it. The plaintiff's lack of awareness of being in prison would, no doubt, diminish the amount of damages he would be entitled to receive. The tort may be committed without the use of physical force, and the use of authority alone is sufficient. In the case of Clarke and Davis, the plaintiff came under suspicion by the police who were investigating certain irregularities at the Public Works Department in Jamaica. He was accosted by the police officers and accused of having drawn pay without having worked for it. He was invited to show the police where he had done the work and later to accompany them to the barracks at Lucca to make a statement. At no time was he physically manhandled or restrained. After making the statement, his money was returned to him and he was allowed to go. The officers were held liable for false imprisonment as they had no reasonable cause for detaining the plaintiff, and the statutory defense available to the officers was therefore not available to them. In the case of Lebrun and High-Low Foods Limited, the proprietors of a supermarket whose manager, suspecting that the plaintiff had stolen an item from the store, called the police. The constable detained the plaintiff for a few minutes in the car park, while he searched the plaintiff's car. He found no stolen goods and the defendants were held liable for false imprisonment. In the case of Robinson and Balmain Ferry Company Limited, in this case the defendants operated a ferry and charged 1 penny on entry to the ferry and another penny on exit. The plaintiff paid to enter but then decided not to travel on the ferry and demanded to be allowed to leave. The defendants refused to allow him to leave unless he paid the required fee. It's held that the defendants were not liable for false imprisonment because the condition that 1 penny be paid on exit was a reasonable one to impose. The occupier of the premises is entitled to impose restrictions by way of contract on the right of visitors to leave the premises without being liable for false imprisonment. So the defense to false imprisonment is lawful arrest. This is the main defense. So police officers, and to a lesser extent private individuals, have statutory and common law powers to arrest suspected offenders. An arrest may be lawfully carried out under a valid warrant obtained from a magistrate. The onus of proof that the arrest was lawful is on the defendant. It has been said that the duty of the police when they arrest without a warrant is to be quick to see the possibility of a crime, but to be equally quick to avoid mistaking the innocent for the guilty. So remedies for the tort of false imprisonment. As per usual, damages. So the court is required to assess the damages to be paid to a successful claimant. There are a few rules established for the assessment of damages in cases of false imprisonment. The quantum is very much left to the discretion of the judge. As in cases of assault and battery, in addition to compensatory damages, exemplary damages may be awarded against the Attorney General for any oppressive, arbitrary, or unconstitutional act by a government officer, such as a police officer. So in the case of Quashie and AG, in this case the plaintiff was a member of a gang of laborers weeding and cutlassing the roadside. He was unlawfully arrested by 2 constables. He was struck and pushed several times by the constables, then handcuffed, taken to the police station, detained for 14 hours, all the while not being told of the reason for his arrest or detention. He was later charged with using obscene language, resisting arrest, and assaulting a police officer in the execution of his duty. The charges were dismissed by the magistrate. He sued the constables for assault, false imprisonment, and malicious prosecution. It was held that the constables were liable. The judge took into account a number of factors in arriving at an award for aggravated and exemplary damages, and these included loss of liberty, injury or damage to reputation, imprisonment for a considerable period without a charge having been brought, being handcuffed for 14 hours, thereby preventing him from taking refreshment, failure to inform him of his reason for his arrest, failure to tell him of his right to an attorney, injury to feelings, that is, disgrace, humiliation, mental suffering, the high-handed and aggressive manner in which he was unlawfully arrested, physical injury, illness, or discomfort arising from the detention, any pecuniary loss which is not to remote a consequence of the imprisonment. So, for example, loss of business, employment, or property. So now we're going on to the tort of malicious prosecution. The tort of malicious prosecution is committed where the defendant maliciously and without reasonable and probable cause initiates against the claimant a criminal prosecution which terminates or is decided in the claimant's favor and which results in damage to the claimant's reputation, person, or property. So in the case of Rowe and Port of Spain City Council, the judge set out the essential ingredients for proof of the tort of malicious prosecution, and he set them out as that the defendant set in motion criminal proceedings against the claimant, that the prosecution terminated or the matter was decided in the claimant's favor, and that the prosecutor set the law in motion without any reasonable or probable cause, and that in doing so the prosecutor was actuated by malice. So failure to prove any one of these ingredients that I mentioned will result in the claimant losing his action. So he has to prove all. So we're going to look at the requisite details as listed above before. So institution of proceedings. The claimant must show that the defendant instituted the proceedings or was actively instrumental in setting the law in motion against him. Where a police officer is the defendant, the requirement will be easy to satisfy, as prosecutions are almost invariably instituted and conducted by the police. Where the defendant is a private person, he will not be liable merely because he gave information to the police, as a result of which the police decided to prosecute. Secondly, termination of prosecution in the claimant's favor. So all that is required is not that the claimant was acquitted, but that he was not convicted. So it means that he was successful in his defense of the prosecution. Thirdly, absence of reasonable and probable cause. This is perhaps the hardest requirement to satisfy because it involves proof of a negative, which is a difficult task. It is for the claimant to establish the absence of reasonable and probable cause, not for the defendant to disprove it. So the question the court must ask is whether a reasonable person having knowledge of the facts which the defendant knew at the time he instituted the prosecution would have believed that the claimant was probably guilty of the crime imputed, and this is the objective test. And then whether the defendant did himself honestly believe that the claimant was guilty, which is a subjective test. Fourthly, malice. The claimant must prove that the defendant instituted his prosecution with malice. And malice in this case includes any improper motive other than simply instituting a prosecution for the purpose of bringing a person to justice. So if the prosecutor had no honest belief in the guilt of the accused, this would be evidence both of lack of reasonable and probable cause and also of malice. And that brings us to the end of trespass the person. I hope you all enjoyed that and look out for my other video. Like and subscribe. Take care.